Motion, item 1.
It is your lordship. Lordship,
Yes.
your lordship, this petition is for quashing of the DRI case, which is still pending before the CJM's court in Aizawl. The petitioner is an accused person, your lordship. In the present pending case, this DRI case has been pending for 4 years and 15 days till today,
Yes.
without filing any final complaint, your lordship. And the seizure was made in pursuance of the intelligence input received by the DRI, your lordship. Seizure was made on 6th February 2022. Seizures were made for some cigarettes and poppy seeds and other cosmetic items. And nothing was seized from the present petitioner, your lordship.
How he was implicated?
It was stated that she is, the allegation is that she is the owner. But it was those seized items were not seized from her possession, not from her custody. She was in Bangalore at that time. And the next day she was called through phone call, and when she reached Aizawl, she was arrested. And thereafter she was released on bail. She was released on bail, and thereafter, your lordship, final complaint could not be filed. She appeared time and again before the CJM's court.
Yes. What is happening? Why not?
Lordship, I'm representing the respondent number 1 and 2, and I'll accept notice on behalf of them, Lordship. Then I'll obtain instructions.
Yeah, please
As-
take instructions. Okay, I heard Mr.
B.L. Ramenga.
B.R. Servicer, the learned counsel, appearing for the petitioner. Also heard Mr.
Johnny L. Tocho,
for respondent numbers 1 and 2.
1 and 2.
Your CGC,
I'm a special PP for the
special PP for DRI.
DRI, Lordship, yes.
Special PP for DRI, correspondent number 1 and 2. This is an application under section 528 of BNSS 2023, praying for quashing of the complaint registered as Directorate of Revenue Intelligence in bracket DRI, case number 01 stroke CL stroke IMP stroke POP dash GIG dash COS stroke DRI stroke AZL stroke 2022 dash 23, connecting to a case under section 135 1A and B of Customs Act 1962. Let notice be issued on respondent numbers. Let notice be issued returnable in 3 weeks. Notice to respondent number 1 and 2 is dispensed with, as the learned special counsel DRI has put in his appearance. Notice to respondent number 3 and 4 by speed post. Steps for notice to be taken within a period of 3 days.
3 days, my lord.
A period of 3 days. Let the matter be listed after 3 weeks.
I oblige.
Orders, item 2.
Yes, Mr. Malhotra.
Right, please, sir. This is an application for condonation of delay
Yes.
of 1163 days.
How many days? 1100?
63 days. Your
63 days.
Worship,
Okay. What were the reasons that why you were so late?
Your Worship, if I may take your lordship to the annexure 1,
Annexure 1.
page 10.
Yes. This is 7/12/2021.
Yes, Your Worship. This is the date when the final hearing was conducted, Your Worship.
Yes.
Then, if your lordship will see, at page
Yes, page
Page 15,
15, 15.
1-5.
Yes.
Judgment order is reserved for 21st of January 2022. As you watch at the top of the page, JO is reserved.
Page 15 you are referring to, right?
Yes, annexure 2.
Uh-huh.
Top of the page,
Uh-huh. Judgment and order is reserved for, okay.
21st. So, Your Worship, the final hearing was conducted on 7/12/21, and JO was reserved for 21st of January 2022. Then, if Your Lordship will see just the second part, 24th of January 2022, court is adjourned as the trial judge is on leave, fixed 18 February 2022 for JO. If Your Lordship will see, there's no signature of the presiding officer. Again, on 18th of February 2022, court is adjourned as the trial judge is on official duty. Fixed 25th of March 2022 for JO. Again, Your Worship, no signature of the presiding officer on the right column. So, Your Worship, whether these orders were passed by the presiding officer or by someone else, no signature of the concerned judge.
Presiding officer.
Yes.
Similarly, dates have been given
Yes.
later on also.
Yes. So, Your Worship, on 2 occasions, the case was adjourned for JO without the signature of the presiding officer, and no summons were issued to the defendant number 4, the present appellant, for passing of the judgment. And at page 17, Your Worship,
Yes.
this is 25th of March 2022. Plaintiff and defendant number 1 to 3 are present through learned counsel respectively. Defendant 4 is absent without cause despite several chances given to him since at the stage of plaintiff's evidence. JO is pronounced in an open court in presence of both parties and is kept in original in SIA. Case is disposed of. So, Your Lordship, if Your Lordship will see page 15 and page 17, the judgment was reserved for 24th of January 2022. On 24th of January 2022, the trial court was on leave. The trial judge was on leave. It was adjourned to 18th of February 2022. There's no signature of the presiding officer. On 18th of February 2022, again the case was adjourned as the trial judge is on official duty.
Yes.
And on both these occasions, Your Worship, no notice was given to the defendant number 4 regarding the date fixed for delivery of judgment. In this regard, Order 20, Rule 1 says that when the judgment is fixed for a subsequent date, notice has to be given to the parties.
You said order to order?
20, Rule 1.
Yes, order
CPC.
20. Yes.
So, Your Worship, the humble submission of the petitioner is, Your Worship, that no notice was issued to the appellant defendant number 4 regarding the delivery of judgment on this specific date. So, we were not aware of the delivery of judgment on 25th of March 2022. So, and the appellant only came to know about the existence of the judgment when he received the order, which is at page 19, English translation. He received this detailment order from the Revenue Department. This is dated 26th of November 2024. On this date, Your Worship, this is the detailment order issued by the Assistant Survey Officer, Land Revenue and Settlement Department. As per the order number so-and-so dated 25th March 2022, passed by the Senior Civil Judge, Aizawl Judicial District, Sejib, you are hereby informed that the land dispute between the appellant and the respondent pertaining to LSC number so-and-so located at Lungrang land shall be redemarcated on 3rd of December 2024. And F. Lal Singh Liana survey is appointed to do the needful. So, Your Worship, after receiving this order and on 3rd of December 2024, when I was present at the site, I was informed by the revenue authorities that the judgment had already been delivered on 25th of March 2022 by the trial court. So, before this, I had no knowledge regarding the delivery of the judgment. And if your Lordship will see from the order sheet, although the judgment was supposed to be delivered on 24th of January 2022, it was postponed, adjourned by the court on 2 occasions. Once because the trial judge was on leave, and again once because the trial judge was on official duty at page 15. But both the orders were not signed by the judge, honorable judge, and no notice was issued to the defendant, number 4, regarding the delivery of judgment on the proposed day. Order 20, Rule 1 says, Your Worship, notice has to go to the parties regarding delivery of judgment, which has not been
Done in this case.
complied with. Then, Your Worship, so I came to know about the judgment only on 3rd of December to 2024.
On 3rd of December.
Yes, when the detailment order is 26 November 2024.
But like you were
I was directed to be present at the disputed site on 3rd of December 2024. Page 19, Your Worship.
So when did you receive this? 26 November?
Yes, this I received on 26, Your Worship. But then, as per this, there's no clarity that the case had already been disposed of. It is just as per order number so-and-so dated 25th March. Then, when I went to the disputed site for redemarcation on 3rd of December 2024, I was informed by the surveyor that the matter has already been decided by the trial court.
Correct.
Thereafter, if I may take your worship to page 4
Page 4.
of the application.
Yes.
Your Worship, this is my explanation subsequent to 3rd of December 2024 for the
Yes.
delay. Page 4, ground number 8, Roman 8.
Ground number 8.
Yeah, this is the explanation for the delay subsequent to 3rd of December 2024. The applicant defendant has subsequently gone to Aizawl on 10th of December 24 to consult his lawyer about the disposal of the suit by the trial court in favor of the respondent number 1 plaintiff as informed to him by the representative of the Revenue Department, Sirchi District, and what remedies were available to him. The lawyer for the applicant defendant number 4 had then advised him to first obtain a copy of the judgment on order dated 25/3/2022 from the trial court and to consult him again thereafter. The applicant defendant number 4 had returned to his hometown. He is not from Aizawl. He is from Thenzawl, which is about 3-4 hours drive from here.
Okay.
The applicant defendant number 4 had returned to his hometown on 13th December 2024, but due to winter vacation, the applicant defendant number 4 could not take immediate steps for obtaining certified copy of the judgment order dated 25/3/2022. After the courts had reopened in the 3rd week of January 2025, the applicant defendant number 4 had requested his lawyer to obtain certified copy of the judgment and order dated 25/3/2022, along with the copies of necessary documents, and the lawyer for the applicant defendant number 4 had informed him that he would take necessary steps. Applicant defendant number 4 had then approached his lawyer the last week of February 25 to inquire whether his lawyer had obtained the certified copy of the judgment and order dated 25/3/2022, along with the other necessary documents, but his lawyer had failed to obtain the same. Thereafter, on the request of the applicant defendant number 4, his lawyer had applied for certified copy of the judgment order dated 25/3/2022 and other necessary documents on 10/3/2025, which were furnished by the trial court on 5th of June 2025. After obtaining certified copy of the judgment order dated 25/3/2022 and other necessary documents, the lawyer for the applicant defendant had informed the applicant defendant number 4 on 11/6/2025 to come to Aizawl to discuss the matter. However, the applicant could not go to Aizawl on 11/6/25, and he could go to Aizawl only in the middle of July 2025 to consult his lawyer due to the ill health of his wife, Srimati Lal Swangi, who is suffering from menopausal syndrome with diabetes mellitus with diabetic neuropathy since 2023. Next, Your Worship, the lawyer for the applicant defendant number 4 had then informed him that since he did not take up matters in the High Court, it would be better for him to approach some other lawyer. The applicant defendant number 4 had then approached his present lawyer in the first week of August 2025. The present lawyer for the applicant defendant had taken about 22 days to study the case and prepare the appeal along with the continuation of delay application. Accordingly, Your Worship, the connected appeal was filed on 28th of August 2025.
28th of August.
Yes. Now, Your Worship, if we calculate the delay from the date of the judgment, which is 25/3/2022, there's a delay of 1163 days. But if we calculate the delay from the date of knowledge of the judgment, which is 3rd of December 2024, there's a delay of 178 days. Because the applicant gained knowledge
And
of
what
the
is the limitation period for this?
90 days. Your Worship.
90 days.
Your Worship, I'm relying on 3 judgments.
Yes.
2023, volume 18 SCC 764.
Paragraphs?
Your Worship, I'll take your Lordship to paragraph 4. If I may read, Your Worship.
Yes.
Paragraph 4.
Yes.
It is in that light, the appellants are before this court in this appeal. At the outset, having taken note that the contention in the appeal before the lower appellate court was that the judgment was not in the knowledge of the appellants herein, that aspect of the matter was required to be kept in view by the lower appellate court, since the appellants in fact had not taken effective part except filing written statement. When there was a delay of only 52 days in filing the appeal, and furthermore, when the parties were litigating with regard to the right over immovable properties, which is the same case here, the substantial rights were to be decided between the parties, the delay could have been condoned and the appeal could have been decided on merits. Para 5, Your Worship, the Honorable Supreme Court has referred to the case of Collector Alia versus Tatiji, very famous case, Your Worship. Then if I may take Your Worship to paragraph 6.
Yes. Yes.
The above decision expressing the intention of justice-oriented approach percolating down to all the courts was rendered nearly 3 decades ago, but unfortunately the case on hand demonstrates the pervading insensitive approach, which apart from continuing the agony of the litigants concerned has also unnecessarily burdened the judicial hierarchy, which after going through the entire process will have to set the clock back at this distant point in time and prolong their agony. If only the court concerned had been sensitive to the justice-oriented approach rather than the iron-cast technical approach, the litigation between the parties probably would have come to an end much earlier after decision on the merits of their rival contention. So, the Honorable Supreme Court had condoned the delay.
Yes.
So, my humble submission is that, Your Worship, it should not be a technical approach and it should be a justice-oriented approach in deciding matters regarding continuation of delay.
Yes.
And Your Worship, so this is a judgment of the Allahabad High Court, 1981 SCC online, Allahabad 268. Your Worship, this is a case with regard to land acquisition matter, and the award was passed in favor of the landowners, the respondents herein, and and they had gone in reference. The reference court had made only the collector as a party to the reference proceedings. The present appellant, National Thermal Power Corporation, were not made a party in the reference petition. So they were not aware of the judgment passed by the reference court. After they became aware of the judgment passed by the reference court, they preferred an appeal, which was dismissed by the High Court. Then they went to the Supreme Court. So I'll take your Lordship to para 8. If I may read para 8.
Yes. Yes.
These decisions make it amply clear that the company for whose benefit land acquisition proceedings are taken is an interested person entitled to take part in the proceedings before the district judge and to file appeal before the High Court against judgment of the district judge. Section 54 of the Act provides for appeal to the High Court against judgment and decree of the district judge passed in reference proceedings in accordance with the provisions of the Code of CPC. Section 96 of the CPC provides for appeal to the High Court from original decree. Limitation for filing appeal before the High Court against a decree or order of the district judge under the Code of CPC is 90 days from the date of decree or order as prescribed by Article 116A of the Limitation Act. It would be seen that the limitation for filing appeal before the High Court commences from the date of decree or order. According to the strict literal meaning, the period of 90 days would be computed from the date the judgment or order is pronounced. Para 10. The question arises when the period of limitation will commence if the judgment is pronounced in the absence of the parties or their counsel on a date of which no notice is given to them. If the date on which the judgment was pronounced is taken into account for the purpose of computation of limitation, great injustice would be caused to the party concerned without any fault on its part. It is well settled that in the absence of communication of the order, right of the party concerned cannot be affected. Ordinarily, an order takes effect on its communication to the parties. Communication is the essential element of an order. This is a basic element of fair play and natural justice. In Raja Harish Chandra Raj Singh versus Deputy Land Acquisition Officer, AR 1961, Supreme Court 1500, the Supreme Court considered the expression the date of collector's award as occurring in Section 18(2)(b) of the Act. Supreme Court observed where the rights of a party are affected by any order and limitation is prescribed for the enforcement of the remedy by the person aggrieved against the said order by reference to the making of the said order. The making of the order must mean either actual or constructive communication of the said order to the party concerned. So the knowledge of the party affected by the award made by the collector under Section 12 of the LA Act 1894, either actual or constructive, is an essential requirement of fair play and natural justice. Therefore, expression date of the award used in Proviso B to Section 18(2) of the Act must be the date when the award is known by him either actually or constructively. It will be unreasonable to construe the words from the date of the collector's award used in the Proviso to Section 18 in a literal or mechanical way. Para 11. Supreme Court again considered the question in State of Punjab versus Quaisar Jahan Begum, AR 1963, Supreme Court 1604. On an application made by Quaisar Jahan Begum, the collector made a reference to the court under Section 18 of the LA Act for determining compensation. On behalf of the state, an objection was raised that the reference was incompetent as application was made beyond the prescribed period in Clause B of a proviso to Section 18 of the Land Acquisition Act. The award was given by the collector on October 25, 1953. The objector made an application for interim payment of compensation on December 25, 1954. But the requisite application for making reference to a civil court was made on September 30, 1955, almost after a period of 2 years from the date of the award. The state raised the plea that reference was incompetent as the application under Section 18 had been made beyond 6 months from the date of the award. Supreme Court repelled the contention and observed a literal and mechanical construction of the word 6 months from the date of collector's award occurring in second part of Clause B of the proviso would not be appropriate, and the knowledge of the party affected by the award, either actual or constructive, being an essential requirement of fair play and natural justice. The expression used in the proviso must mean the date when the award is either communicated to the party or is known by him, either actually or constructively. Whether the award was never communicated to the party, the question is, when did the party know the award, either actually or constructively? In Madan Lal versus State of UP, 1975 2 SCC 779, Supreme Court again construed the expression date of order for the purpose of computing limitation for filing appeal under Section 17 of the Indian Forest Act 1927. Section 11 provided limitation of 3 months from the date of the order for filing appeal. Supreme Court held that limitation would run from the date the aggrieved party came to know of the order and not from the date the order was actually passed. The law as declared by the Supreme Court in the aforesaid decision makes it amply clear that it is fundamental principle of justice that a party whose rights are affected must have notice of the order, and in absence of such notice, his right to appeal cannot be taken away without there being any fault on his part. Fair play and natural justice require that the party should be given notice of the award or the order, and in the absence of notice, limitation for filing appeal would run from the date the party acquires knowledge of the order. If I may tell para 18.
So in your case, I mean, you are saying that like delay is only 178 days and 170 days have been explained.
Yes, because as per Order 20 Rule 1, notice has to go to the parties regarding delivery of judgment. As per the records, order sheet, no notice was given to the parties regarding delivery of judgment. In fact, when the matter was adjourned, the presiding officer did not sign the order sheet also. So if we take the number of days delay from the date of knowledge, it comes to 174, which has been explained by us. That is the mean. And there's one third judgment also on the same line, Josh. 1963.
Is there any more paragraphs you want to rely on for this in this case? The Allahabad one?
Yes, Your Honor. Anyway, para 18.
Para 18.
Yes. And para 24. Para 18, 24, and 25. So ultimately, Your Worship, the delay was condoned because no knowledge of the judgment award was given to the other side, to the appellant. So the Honorable Supreme Court, the Honorable Court held that if the delay is counted from the date of knowledge, it was within time. In this case,
was there any discussion on the vigilant? I mean, you being a party there.
Yes.
Whether you should have been a little bit vigilant about your case going on there. Is there any discussion on that point in any of the cases? Yeah, it is true that there is a statutory mandate that a notice should be given.
Yes.
But still,
in this case, we have held that since no notice was given to us, and Your Worship, even the trial of the court, if Your Lordship will see the order sheet, from 2016 to 2019, the records were misplaced. And when it was regularized, no proper notice was given to the present appellant. If I take Your Lordship to the affidavit filed by the respondent at page 23. Sorry, at page 12.
yes,
Your Lordship will see the order dated 1st of September 2016.
yes,
Parties are present through their respective counsels. The following preliminary issue is framed. Whether suit is barred by limitation, fixed 2916 for hearing. Now, if Your Lordship will see the next page. The next order is passed on 26th of April 2019,
yes,
after more than 2 years. Case record put up as it was misplaced. Case is regularized. As settlement order dated 9 September 2010 had been passed by ASO, said sheet, and order was not appeared to be followed, the cause of action runs from that day, and hence I opine and hold that the suit is not barred by limitation, and therefore suit is maintained. Fixed 22/5/2019 for PE. Give copies of this order to the parties. There is nothing to show that the copy was issued to the parties. So for nearly more than 2.5 years, it was misplaced. And on its regularization, no notice was given to the defendant, the present appellant. So this is the conduct of the trial.
So absolutely no notice.
No notice.
Given. Now after this recreation, no notice.
Yes. At page 23 of the affidavit filed by the respondent.
Page 23, yes.
This is the order dated 25th of
February
2021. Plaintiff is present with learned counsel. Defendant number 4 is absent. No cause. Defendant 1 to 3 are present through AGA. PW1 is present for cross-examination. Defendant 1 to 3 declined to cross-examine him. Several chances were given to defendant number 4 for cross-examination. of PW1 but fails to appear without cause, hence chances closed. Plaintiff close evidence. Defendants are called to adduce evidence, if any, on next court date. Fix 12/3/24 DE. So it appears here summons was issued on 1st of March 2021. But Your Worship, again, like it appears that on the left column, notice may have been issued.
Notice have been issued.
May have been this on the left column, Your Worship.
Notice.
But then, Your Worship, this is the peak time of COVID. This is the time we were doing lockdowns. So the chance of the defendant appearing on 12th of March 2021 was there was no chance, Your Worship. This is the COVID period. Then after that, Judge will see, no notice was issued. And mainly, Your Worship, when the judgment was reserved, then notice should have gone under Order 20, Rule 1, regarding the date of delivery of judgment. No notices were issued, and even the orders were not signed by the presiding officer.
Yes.
And
What about the other case, the Allahabad, another one?
yes, Your Worship, this is on the same line here.
Same line.
Yes,
The paragraphs can you give me?
yes. Para 6, Your Worship.
Para 6.
Yes. In the middle, Your Worship. In fact, it was the fault of the learned law court that the appellant was not given notice under Order 20, Rule 1, CPC. I'll read from Para 10, Your Worship.
Para?
Para 10.
Para 5.
Para 10. Para 10, Your Worship.
Yes.
On the other hand, the argument advanced by the learned counsel for the opposite parties was that Rule 3392 expressly states that the first appeal shall lie within 30 days of the date of the order. The rule, therefore, itself states that the limitation should commence from the date of the order and thereby excludes the application of the principle that limitation should start from the date of knowledge of the order. No doubt, according to the strict interpretation of the rule, limitation should be counted from date of the order. It can, however, be argued that the date of the order cannot be viewed separately from the date of its communication to the party, the one being interlinked with the other. So far as a party is concerned, no order should be deemed to have been passed against him, unless the said order is communicated to him. In this connection, the learned counsel for the petitioner referred to Section 341 of the UP Zamindari Abolition and Land Reforms Act, which lays down that unless otherwise expressly provided by or under the said Act, the provisions of the Code of CPC would apply to proceedings under the said Act. In view of this provision of law, the provisions of Order 20 Rule 1 of the CPC would apply to the present case as well. Order 20 Rule 1 of the CPC runs as follows. The court, after the case has been heard, shall pronounce judgment in open court, either at once or as soon thereafter as may be practicable on some future day, and when judgment is to be pronounced on some future day, the court shall fix a day for that purpose, of which due notice shall be given to parties or their pleaders. Para 11. In view of the above provision of law, learned counsel for the petitioner argued that it was incumbent on the court to give notice to the parties of a date when of the pronouncement of its judgment. The present case is a stronger one because apart from statutory provision mentioned above, the party has also been orally assured by the court that he need not worry by coming to court repeatedly, as notice of the date of the pronouncement of judgment would be issued to him. The party acting on the above assurance ceased to come to the court. In this situation, the learned additional commissioner rightly held that no blame would attach to the party in respect of ignorance of the date of the order, and it was the fault of the trial court that the appellant was not given notice under Order 20 Rule 1 of the CPC. Further, the present case is stronger one because apart from above assurance, the court had on the date of passing the order itself given an express direction to the effect that the parties be informed of the date of the order. White order of the court dated 17 March 1958, which is the date of the order. A copy of the order sheet from the above date is filed as Annexure 4 along with rejoinder affidavit. Therefore, in the present case, in spite of provisions of Order 20 Rule 1, and also in spite of the aforesaid direction of the court to that effect, no intimation was sent to the petitioner conveying the information of the date of the order. Allegation of the opposite party in paragraph 15 of the counter affidavit, on the other hand, is that the petitioner and opposite party number 1 were informed of the various dates which were fixed in the case under section 202 of the UP Zamindari Abolition and Land Reforms Act for passing of the final order. This is obviously wrong. In fact, the finding given in the judgment of the board itself falsifies the aforementioned allegation made by the opposite party number 1 in its counter affidavit. The judgment of the board on this point contains the following finding. The court, however, delivered the judgment and order that the parties be informed. There is nothing to show that any information had been sent to either party. The learned additional commissioner had also given the same finding, and it is on the basis of this finding that he was of the opinion that the date of the order in the present case should be deemed to be the date when knowledge of its existence was first brought home to the petitioner. In respect of the above opinion of the learned additional commissioner, learned counsel for the petitioner relied on principle laid down in Raja Harish Chandra Raj Singh versus Deputy Land Acquisition Officer, the 1961 Supreme Court order, which we have already read.
Yes.
Paragraph 15, Your Worship.
Yes.
Under the above circumstances, I see no reason why the salutary principles laid down by the lordships of the Supreme Court in the above case should not be made applicable to the circumstances of the present case as well. I am therefore in agreement with the view taken by the learned additional commissioner to the effect that in the circumstances of the present case, limitation should be deemed to commence from the date of knowledge of the order by the petitioner. In this view of the matter, the appeal filed before the additional commissioner would be within limitation and no question of condonation of delay would arise. The board in their judgment completely overlooked this aspect of the matter, which was emphasized by the learned additional commissioner in his judgment. So the appeal filed before the additional commissioner, he had condoned the delay. Then appeal went to the board, revenue board. They dismissed it as being time bound. Then it went to the High Court. High Court agreed with the decision of the additional commissioner that the date of knowledge of the order will be the starting point for counting the limitation period.
Okay. That's all, Mr. Malhotra?
Yes. No.
Mr. Lordship.
Yes.
Lordship, with regard to the applicant's claim of ignorance of knowledge, if your Lordship look into page number 3 of my counter affidavit.
Yes.
Your Lordship, when after the suit was instituted, the applicant appeared before the court, and on 21st of June 2016, he was appearing with his counsel. And if your Lordship look into page number 11 of my annexure, the order dated 21/6/2016. Here, your Lordship, parties are present. Defendant number 4, now the applicant, appeared in person with his learned counsel and submitted his written statement. Now, my Lord, the present appellant has knowledge of the existence of this suit by filing his written statement. However, my Lord, the applicant started deserting the suit from 22nd May 2019 till the pronouncement of judgment on 25 March 2020.
What do you have to say on order 20 Rule 1 CPC?
Regard to Order 20 Rule 1 of the CPC, if your Lordship kindly look into the Order 20 Rule 21, Rule 1, it clearly states that notice shall be given to the parties or through his pleaders. And if Lordship peruse the whole application of the applicant, there is nothing, even the acknowledgement letter from the learned counsel in the lower trial court, that notice was not served to him. Because the provision of Order 22 Rule 1 does not state that it must be served only to the parties, but it can also be served to the pleaders.
Where is there that we have served it? Is there any record?
There is nothing on record that the notice was not served to him. Otherwise.
No. I mean, see, there is a specific this thing
Yes.
that he is not present.
Yes.
If notice has been given, then there should be some record saying that like notice has been issued to him. Correct.
Yes, if I may insist your lordship, on November 6, 2020,
Page.
if your lordship look into page number 43. 43.
43.
Yes. If you look into page number 43, your lordship,
Yes.
wherein the order dated 6/11/20, plaintiff are present, defendant is absent with cause that municipal area of Aizawl is under lockdown. It means, your lordship, that till 2020 of November, the applicant are still contesting the suit, because
How-
here
how-
the order itself clearly shows that the time. The cause that, yes.
I did not get it. How do you presume that?
My presumption is, your lordship, that defendant is
What
absent.
about the other case, other date, 1/10/2020?
6/11/20. 6/11/20.
6/11 I have seen.
Here, your lordship, the defendant, now the applicant, has shown the cause that municipal area of Aizawl was under lockdown. It means that till 6/11/2020, the applicant has acknowledged that the suit has been ongoing. The trial is pending.
He was a party to that. He has filed a WS in the
Yes.
case, so he is aware of this. There is no dispute about this.
Yes,
His
yes.
only contention is that like while this lockdown happened, then subsequently certain orders were passed, orders were not signed, and judgment
Your
delivery
lordship-
date was not judgment delivery date was not specifically put into his knowledge. Those are the things he is arguing.
Yes.
He is not saying that like he didn't have the knowledge of the suit.
Yes, my
He did
point
have
is,
the
your
knowledge.
lordship, regarding the absence of signature on 24 January 2022, the order itself is clear. Court is adjourned because the trial judge was on leave. If he was on leave, if the trial judge was on leave, how can he affix his signature on the very day he was on leave? And again, on February 18 February 2022, the judge is on official duty. There is no possibility that he fixed his signature on the day when he was on leave. So his signature was absent. And this itself does not, that's the very matter of the case. And again, with regard to Order 20 Rule 1, your lordship, the contention of the applicant is that no notice was served to him. But if the suit has been contested by them throughout the trial, is there any separate notice required to be issued, or the allegation is that notice was not served to them, but there is no acknowledgement letter from the learned counsel that no notice was served to him.
And once he's
Otherwise-
not received, how he will give the acknowledgement?
But the entire
The
blame,
acknowledgement will be given only when he receives this.
yes, your lordship,
Correct.
if your lordship looked into order at page number 42 of
Page
my
40.
annexure,
42.
yes,
Yes. What is there?
at page number 42, give copy of order to defendant number 4. Here on 3rd July 2020.
3rd July 2020. Yes.
Yes, at this order, it stated the order must be given to the defendant number 4, now the applicant.
On perusal of the orders, it is learned that the defendant who has been absent without cause and has failed to cross-examine PW for 11 number of dates. Hence, last chance is given to the defendant appeals to appear on next date. He appeals. It will be declined. Yes.
Again at page number 44, your lordship. Here at the order 26th of March 2021, copy to defendant number 4. And again on 12 November 2021 at page number 45, copy of order to be given to the defendant number 4 to registered post. So in whole of the cases when the defendant is contesting the trial, it is presumed that the learned counsel must attend the court. So notice the provision of Order 20 Rule 1 does not say that it must be given in writing. The notice can also be in verbal. If the counsel was present there, he can be informed verbally.
Let us see the language in CPC.
Notice shall be given to the parties or through pleaders. It does not say that a written notice, Your Lordship. If I may read, the court shall fix a day for that purpose on
One second,
which.
one second.
Yes.
Yes,
Yes.
read.
Okay. Judgment when pronounced. 1. The court, after the case has been heard, shall pronounce judgment in an open court either at once or as soon as thereafter as may be practicable, and when the judgment is to be pronounced on some future day, the court shall fix a date for that purpose, of which due notice, Your Lordship, shall be given to the parties or their pleaders. Here, the very language is clear that it does not specify that it must be written notice.
If somebody is not there, then who will take the notice? How you will intimate somebody? In the air, or some kind of telepathy thing.
Be-
If somebody is not there, somebody is absent, then how you are supposed to give notice?
Your Lordship, it was a time of pandemic. It was the time of pandemic as claimed by the applicant.
No, see, this Order 20 Rule 1 is very clear.
Yes.
Correct. That if you fix a date
Yes.
for judgment and order, the parties should be notified. Now, how you are going to give notice? Usually, how? What is the procedure court will follow? Court will definitely follow that fixing this, that,
Yes.
on so and so.
Yes.
And notice to the parties. How notice will be given if somebody is not present in the court?
In written form, yes, Your Lordship. That's correct. Yeah, notice will be given in written.
Now,
in that particular case.
I'm asking you how notice will be given.
Through summons, Your Lordship. Through summons or, yes, in written form. So definitely it will
Some
be given.
notice will go from the registry saying that on this date that the judgment and order will be passed in this particular case, something like that.
Yeah, that's correct. But Your Lordship, this cannot only be the sole contention for deciding that case, because Your Lordship, the knowledge, with regard to the knowledge, the applicant claimed that he only came to know the existence of the order when he was served a notice from the respondent number 4 that the area will be demarcated. The demarcation of the area. When notice was served to him, the demarcation of the area will be conducted.
Yes, on 3rd of December he got to know about this.
Yeah, yes,
His knowledge came as per his contention.
yes,
He came to knowledge about the passing of the order in December
Yes.
in 2024.
November 26.
No,
If, 26 November, 24 November 2024. 26 November 2024.
Correct.
Even so, counting from that, Your Lordship, the applicant received letter from the respondent number 4 on 26 November 2024. And even counting from that, his knowledge of the existence of the judgment and order dated 25 March 2024, there is a lapse of 275 days. Even from his knowledge.
no, as per his calculation, it is 178 days.
It was but in my own in my humble calculation, Your Lordship, from the very day that he has been served that notice from the respondent.
He's saying that a notice has been served upon him. He
Yes.
got to know that a date has been fixed for demarcation.
Yes.
So when he went to that particular spot on the day of demarcation, when he was supposed to be present there,
Yes.
that is 3/12/2024. That day only he got to know that there was an order
Yes.
passed.
Even from that date, Your Lordship,
Then-
there's still
and from that
268
date-
days.
And from that date, if till the filing of the appeal, it is 178 days, he's saying.
But Your Lordship, in my humble calculation, there is still 268 days. Counting from 3/12/2024, 268 days. And minus 90 days. Yes. But that should be only after the delay is condoned.
So 90 days you minus, it becomes 178 days.
Yes.
So in 178 days, do you have anything? I mean,
Yes.
do you have any difficulties in his explanation?
Your Lordship, in the whole of the cases, the petitioner came to know 3rd December 2024 that the order judgment order dated to 25/3/2022 was existed, and there was a
Now, what is the stand you have taken in your affidavit?
yes. My stand at first is, Your Lordship, there is a lack of explanation, and number two, that there is no
Lack
need
of explanation of which days? 178 days or prior to that?
prior to that, from the day of judgment, Your
So
Lordship.
prior to that, we have already heard, both of you.
Yes. Okay. Even counting from the date of his knowledge visiting the suit land, that was not properly explained, Your Lordship. The entire claim has been given to the landed counsel in the trial court that he was given instruction to apply for the certified true copy. But after a few months, still he cannot get the certified true copy from the court. And that blame, Your Lordship, there is no acknowledgement letter or there is no explanation from the landed counsel himself that there was a delay from his part.
No, he's not saying it is delay. He said that he took some time to prepare the appeal.
Only few times in his contention, he takes only few times to prepare the appeal. But before that, Your Lordship, the landed counsel in the trial court was given an instruction by the applicant that he must he may get the certified true copy from the trial court. But after a lapse of few months, he still was unable to get the certified true copies. And then he again give instruction to the landed counsel in the trial court. And only after that he obtained the...
So, see, Mr. Counsel, that this is a substantial right which has been taken away from him.
Yes.
Correct. So,
Correct.
the court has to look into that aspect also.
Yes.
And whether he will be prejudiced if any order is passed in his favor, because you will still get the right to contest your case. The only thing is that here is that, like, I mean,
For that, even though the issues is regarding the title and some landed property, but the applicant, the defendant in the trial court, in his own volition deserted the suit. Even though he was given several chances to adduce his evidences, there is no explanation of that, why he deserted the suit. No explanation is given in the application that why he deserted the suit. It means that he has no interest in that suit.
yes, Mr. Malhotra, your conduct was also not very good, very appreciable conduct.
Yes, Your Worship, that is there. But Your Worship, now, yes, we did not pursue the matter during the trial. But
You
Your
have been given sufficient opportunity
Yes.
that I can see from the orders.
Yes, but Your Worship, we'll see. None of the orders were 2016 to 2019. Case is misplaced. After 2.5 years, it is regularized. Then no notice is issued to the defendant number 4. The
What
present-
indulgence, Your Lordship,
Your
notice was
Lordship, see
issued.
the order sheet. None of the orders show that notices were issued. There is no evidence, proof that summons were issued to the defendant number 4. And,
Issue
okay, I
notices.
admit that, yes, my conduct was also not up to the mark. But then, Your Worship, at the time of issuing judgment, notice has to go out as per Order 20 Rule 1. And even in the Supreme Court judgment, the Supreme Court in this case also, at para 4,
Which one?
2023-18 SCC,
Huh.
para 4. If I may,
Yes.
it is in that light the appellants are before this court in this appeal. At the outset, having taken note that the contention the appeal before the lower appellate court was that the judgment was not in the knowledge of the appellants herein, that aspect of the matter was required to be kept in view by the lower appellate court, since the appellants in fact had not taken effective part except filing written statement. So even in this case, Your Worship, the appellant had only filed written statement and not taken effective part. But in spite of this, the delay was condoned. Because Order 20 Rule 1 was no notice of the judgment, pronouncement of judgment was issued to the parties.
Yes, yes. So we'll do one thing. We'll just we have concluded the hearing. We'll pass the order.
Amen.
We'll pass. Well, should we place it for passing the order, or we can place it for an order in the next week and like pass the order?
Judgment is,
That can be done.
yes, judgment is.
Yes. Heard. Heard Mr. A.R. Malhotra, the learned counsel, appearing for the applicant. Also heard Mr.
Ke badal nahi poya.
So for the respondent, judgment, hearing concluded, hearing on the IA is concluded, judgment reserved.
Respondents 2 to 4, the state is also there.
Okay. MS so-and-so representing the state respondents.
Your Lordship, there are some citations that I want to provide. If Your Lordship kindly look into all the
You have
citing
not brought the citations. I was waiting. I have given you a very
In the
lengthy
meantime,
hearing
my
also.
learned friend was called upon.
Because
That's
I
why Your Lordship.
because I have sufficient time. That's why I have given sufficient time to you, both of you.
Yeah. If Your Lordship kindly
You have
take-
given
yes.
the citations.
Yes.
Paragraph numbers you have given.
All highlighted, Your Lordship.
okay,
Yes.
You have not given the paragraphs where?
Your Lordship, I highlighted them.
He's
Okay,
highlighted.
You have marked it. Okay.
Yes.
Okay, fine. That's fine. So in a day or two, I'll give this.
I'm okay.